Okay, today we are going to look at summary assessment 37.20 in your Gatley, page 1269, paragraph 37.20, summary assessment, CPR. CPR introduced a new power of the court to make a summary assessment of the cost when ordering a party to pay costs to another party. As a general rule, summary assessment is required to be made only in respect of fast-track cases and at the conclusion of other cases which have lasted not more than 1 day. Summary assessment in defamation cases would thus only normally arise in interim hearings. Parties intending to claim costs must prepare and serve on the other party at least 24 hours before the date fixed for the hearing a written statement of costs containing information specified in the practice direction. Where there is no summary assessment, the court will order a detailed assessment. Okay. Payment on account. CPR empowered a judge who has ordered a party to pay costs at the end of the trial to order an amount to be paid on account before the costs are assessed. It has been stated that the court should normally order an interim payment in favor of the successful party for an amount less than the likely full amount of assessed costs. But in exercising its discretion, the court could take into account all the circumstances of the particular case, including whether the unsuccessful party wished to appeal and the financial circumstances of the parties. It is now common for the successful party at the end of a defamation trial to seek, in addition to an order for costs to be assessed, an order for payment of a sum by way of costs on account. It has been stated that the court should normally order an interim payment in favor of the successful amount for amount of assessment, but no exercising its discretion, the court should the financial circumstances of the parties. Law of Libel Amendment Act. Law of Libel Amendment Act. In an action for words spoken and published imputing unchastity or adultery to a woman or girl under the Slander of Women Act 1891, a plaintiff shall not recover more costs than damages unless the judge shall certify that there was a reasonable ground for bringing the action. It has been held that a counterclaim for such an imputation is an action within the meaning of the Act. The judge may give a certificate on an application subsequent to the trial. Okay, that was paragraph 37.23. Cause in action under Slander of Women Act. Cause in action under Slander of Women Act 1891. Law of Libel Amendment Act 1888, right? Under Section 5 of this Act, where two or more actions have been consolidated under that section, the judge at trial, if he awards the plaintiff the cost of the action, shall thereupon make such order as he shall deem just for the appointment of such costs between and against such defendants. The wording of the statute would not seem to affect the general rules. That was 37.22, Law of Libel Amendment Act 1888. Previously, we read paragraph 37.23, costs in action under Slander of Women Act 1891. All right, up next, we are going to do 37.24, costs on acceptance of an offer of amends. Costs on acceptance of an offer of amends. If an offer If an offer to make amends under Section 2 of the Defamation Act 1996 is accepted by the aggrieved party, and the parties thereafter do not agree on the amount to be paid by way of costs, it is to be determined by the court on the same principles as costs awarded in court proceedings. Appeal against cost orders. Okay, we might write this one out. Appeal against cost orders. Right? An appeal against any order relating to costs requires permission. Appeal against any order relating to costs requires permission to appeal to be granted either by the trial judge, to be granted either by the trial judge or the Court of Appeal. Or the Court of Appeal. No distinction is made between orders against parties, non-parties, or their legal representatives. No distinction is made between orders against parties, non-parties, or their legal representatives. Non-parties or their legal representatives. Okay, para Conditional Fee Agreement 37.26. Conditional Fee Agreements. $37.26 Conditional Fee Agreement. Conditional Fee Agreement. Captain, how you doing? Good, good.